Hello friends, in the series on the income tax cases, today we will discuss the issue of ad hoc additions which are being made in the various assessments, and these ad hoc additions are being made without giving any specific defect into the books of accounts and just by making journal comments, journal observations by the assessing officer, like bills and vouchers are not in the proper format, vouchers are not signed by the recipient, bills are not in the proper format. So the moot question in this case was that whether these type of disallowances are justified without ignoring the books of accounts or without rejecting the books of accounts of the assessee, or just by making the journal comments. The name of the case is ZHENG YUAN Mobiles Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 109 ITR short notes 71. The matter has been decided by Delhi ITAT H bench and the date of the judgment is 11th January 2024. In the present case, the assessee is in mobile business. The turnover of the assessee is very huge. The turnover is 576.98 crore. During the assessment proceedings, the assessing officer observed that the assessee was incurring the loss, and the case was selected for scrutiny just to establish the relation between the turnover and the profit shown by the assessee, because in this case the turnover was huge, the loans were huge, but the profit element was nil or it was loss in the present case. So the main duty of the assessing officer was to examine the expenses. The assessing officer was examining the expenses, and during the examination of some expenses like guest house expenses, maintenance expenses, showroom expenses, staff welfare expenses, business establishment expenses, the assessing officer observed that the assessee is not maintaining proper bills and vouchers. The vouchers are not signed by the recipient, bills are not in proper format, and the amount involved in these expenses was near about 3.39 crore. The assessing officer take a very easy way to make the additions and made an addition of 30% of these expenses. If we see the quantum of addition in comparison to the turnover of the assessee, it is very nominal, because the turnover is near about 576 crore and the addition is 30% of the 3.39 crore. But the good point was that the assessee challenged this addition also, and when the matter was before the CIT appeal, as all we know nowadays, behave like second assessing officer. So the assessee was before the tribunal. When this matter came to the tribunal first of all said that in the present case, the assessing officer did not pointed out any deficiency into the books of accounts. It was the observation of the tribunal that the assessing officer has only inferred that the expenses are excessive and unreasonable. It is a trite law that the assessing officer cannot sit into the armchair of the assessee and can decide the magnitude of the expense. Only what is important is that the rendition of the services, if the services have been rendered and the payment has been made, that is sufficient to allow the expenses under section 37. Tribunal also said that AO did not mention any particular defect into the books of accounts and did not challenge the financials of the assessee. It was also the observation of the tribunal that the assessing officer failed to comment on the profit calculation of the assessee, and at the end the tribunal said that these type of additions are not justified when the turnover is so huge and the challenge to the expenses is a very nominal amount, because the duty of the assessing officer is to consider the nature of the business of the assessee also, because sometimes nature of the business also warrant that some expenses are to be incurred where the assessee is not able to procure the bills in the proper manner. For example, in the construction business, when some expenses are incurred at the place of the site where the construction is going on, or like in this case of mobile business, it may happen that some staff is sent to the field work, and in that field work it is not always possible to take all the bills in the proper format or take the proper vouchers. So the nature of the business of the assessee is very essential in determining any disallowance of the expenses. At the end of this video, once again I am repeating the name of the case. The name of the case is ZHENG YUAN Mobiles Private Limited versus Deputy Commissioner of Income Tax, and this case has been reported in 109 ITR Tribunal Short Note 71. The matter has been decided by Delhi ITAT H bench, and the date of the judgment is 11th January 2024. Thank you, friends.